the oxygen principle is to be used as a shield, not as a sword. Yes? So it is actually a defense, or rather a response to appeal. You see that? You use it to respond to an attack. You don't use it to attack. So you cannot say quietly, Judge, I am filing this thing of mine 1 day late, but use the oxygen principle to ignore the delay anyway. No. No. The oxygen principle is to be used as a shield, not as a sword. Right? Now, when we spoke about POs last time, we said that POs can be based on an issue of substantive law or procedural law. Now, with respect to procedural issues, some defects can be fatal and some non-fatal. So the overriding objectives cannot help you if the problem is a substantive law matter. It cannot help you. Doesn't matter how high you wave it and how loudly you wail and scream, begging for mercy. None will be extended to you. No amount of oxygen can revive a dead organism. If the organism is dead, it is dead. Sorry, even if you bring pure oxygen from wherever, you cannot revive it. Now, even some procedural requirements are so serious that violating them means too bad. But there are things where the court may exercise a bit of discretion. Yes, there's a procedural defect, but not so serious as to that the ends of justice demand that we overlook this mistake, this problem, or we allow room for rectification of this mistake. Right? So, we borrowed this from the British their procedural rules have become so technical, cases were being thrown out all over the place because of rules of technicalities of procedure. And so the Lord Wolf report said, well, yes, procedure is the hard maiden of justice. Procedure is important. I mean, you can imagine legal practice without rules of procedure. It will be total chaos, isn't it? Yeah, you can't practice law without rules of procedure. But, well, nobody is perfect. Mistakes occur. Some of them so minor, so small, which can be overlooked, can be ignored, or can be rectified, maybe with an order of causes or something, and then we move on to the substantive issues in dispute. All right? So the statutory provisions there preceded the 2010 Constitution, but in the Constitution itself, we put in there something similar. We did not call it overriding objective, but Article 159 is more or less in similar terms. But it is not a blank check. Every time I discuss this, there are two examples of the bad old days that I like giving, just to show you how things had become really. The Court of Appeal was particularly notorious for striking out and dismissing appeals, records of appeal, notice of appeal, for the slightest infractions. You know, one primary document missing, record struck out. You did not paginate your record of appeal, strike out. You did not number the paragraphs there after every 5 lines, struck out. You know, the flimsiest of them. The High Court also had begun copying that kind of practice. There are 2 examples I like, just to, to show you how this had become serious. Before we changed, the rules in 2010, the civil procedure rules, with respect to applications, the old civil procedure rules said that a party who wishes to oppose an interlocutory application may file grounds of opposition or reply affidavit. That was the old rule. Now today, Order 51 is saying you can file replying affidavit and or grounds of opposition and or PO. Now, in the old rules, this respondent, in answering an application, files grounds of opposition and a replying affidavit. Aha! What does the applicant do? PO, my lord, High Court of Kenya. My lord, PO. Why? My lord, look at the words. My lord, the word is or. Or, my lord. Disjunctive. My lord, you cannot file both grounds and replying affidavit. And by filing both, my lord, that is fatally defective. And both of them should be struck out and the application allowed as plain, as if it is unopposed. And a judge of the High Court says, I agree. Application allowed. It's a real ruling. It's in one of my old folders. Those bad old days. One of my old box files has that ruling. I was not involved in the case, but these were, you could use it in another case if you want to cut corners. Now, in another suit, the order dealing with applications, the last one there says, even in the current rules, every application shall bear at the foot the following words. If any party served does not appear at the time and place stated above, the application may be heard and orders made as the court may deem expedient. This applicant files an application. Very nice, everything, grounds, supporting affidavit, everything. Except that they omitted to write those words at the foot of the application, the bottom. What does the respondent do? PO, my lord, PO. Why? My lord, this particular rule is in mandatory terms. My lord, the word is shall. Every application shall bear the following words. This one, my lord, does not bear those words. Fatal. It should be struck out or dismissed with costs. And the whole judge of the High Court says, I agree. Application fatally defective. That is how we used to practice law those days. Now, the oxygen principle really is meant to deal with such situations. But it is not a blank check. Even the constitutional clause 159, the courts have said many times, for example, in this case, Lake Turkana Wind Power Limited versus County Government of Marsabit, Court of Appeal is saying, I quote, we are content to state that the constitutional provision, that Article 159 thing, is not meant to whitewash every procedural failing, and it is not meant to place procedural rules at naught, meaning zero. In fact, there is great utility in complying with the rules of procedure. It is great utility. And so, in conclusion, what we are saying is this: in doing our lawyering business, let us comply with all the rules in the book. However minute, however small, let us comply with all the rules. We can only invoke the aid of the court on the basis of the oxygen principle if it is something that the court has discretion about. Some things there is little the court can do. But also remember, our judicial officers, judges and magistrates, come in all manner of shapes and sizes. They are those judicial officers whose jurisprudence is procedure. Their entire orientation is the slightest violation of the rules throughout. But there are other judicial officers who are a lot more liberal in their approach to issues. So as counsel, the safe thing to do is comply with the rules. Then you're on the safe side. But should you slip, or as we all occasionally do, then you can invoke oxygen in those situations where some bit of oxygen can revive the patient.